What are the 5 legal documents that every fundraising process needs? Shortly after kicking off confirmatory due diligence, your legal team will begin drafting binding legal documents for your funding round. This set of documents dictates the terms of the transaction, the rights and obligations of investors, and changes to your company charter. These terms here are binding and supersede those of your term sheet. Having an experienced attorney by your side is absolutely critical, someone well-versed in the nuances of fundraising documentation. Alright, let's break it down for you. The Stock Purchase Agreement, or SPA. It's where a lot of the action takes place, detailing economic terms like purchase price, amount of stock being sold, and all other matters like representations and warranties for both the company and investors, indemnification provisions, closing conditions, and other key terms. Think of it as what you're buying and what your promise agreement. It's heavily negotiated. Key terms include economic terms, including the price per share and total investment amount. These should not be a surprise, as they're typically hammered out well in advance. Representations and warranties. These are assurances about your company's current state and its future, covering everything from legal compliance to intellectual property. The company is basically laying it all out on the table, making statements of fact called representations, or reps, about its current situation and promises for the future, called warranties, when it comes to the legal and financial specifics about the company and its shares. These reps outline in detail the company's operations, from ongoing legal battles to the company's intellectual property holdings. To cover any exceptions to these reps and warranties, you've got a disclosure schedule that comes with the SPA. For example, the SPA states that the company is in the clear when it comes to litigation. But if there's a lawsuit brewing in the background, you'd need to disclose that in the disclosure schedule. In fact, it's a smart move to include as much detail as possible in the disclosure schedule. Think of it as your shield against any future claim by the investor. Indemnification provisions outline compensation from one party to another for certain claims. Closing precedents, or CPs, refer to conditions that must be met prior to closing the transaction. For example, a company may have as a CP clearance from antitrust regulators before a transaction can go through. The Investor Rights Agreement, or IRA, outlines critical investor privileges, including preemptive rights, which allow future investors to invest in future rounds before the round is opened up to others; information rights, providing access to things like the company's financials; registration rights, which allow investors to sell their shares in an IPO; and redemption rights, which allow investors to require the company to repurchase their shares after a certain period of time. This is rarely exercised. Note that many of these rights may only be afforded to major investors, which are investors who meet a minimal ownership threshold, say, for example, 10%. Third, the voting agreement defines how shareholders vote on specific issues, introducing mechanisms like a drag-along right, whereby the minority investors can be obligated to vote in the same way as the majority on a particular issue, especially during liquidity events. Number 4, the right of first refusal, or ROFR, and co-sale agreement. The ROFR allows the company first dibs on purchasing shares of any shareholder who wishes to sell their shares. For example, if a shareholder wants to sell their shares to a third party, the company would have a ROFR purchase the stock at the same terms as the third party that is being offered these shares. If the company doesn't want to buy the shares, certain current investors may have a secondary right of refusal. This is important to keep in mind for investors, as they may seek to increase their ownership for your company over time. The co-sale right allows shareholders to join in a sale of shares by other shareholders. In our example, if the company does not exercise its ROFR, in this instance, other shareholders with the co-sale right could join the initial seller and sell their shares to the same buyer at the same terms. This would allow investors to lower their exposure to your company. With every funding round, your company's certificate of incorporation needs an update to reflect the rights attached to the new class of preferred stock being issued to investors, detailing everything from liquidation preferences to anti-dilution protections. It's a key document that underpins the structure of your startup's equity. There are some terms you should be familiar with. First are anti-dilution provisions, which provide investors protection in the event of a down round. Pretty simple. If there is a down round, which is when you raise at a lower valuation than the last round, which is not a good thing, investors would get anti-dilution shares to make up for the additional dilution that they would incur. It's not typical to see this at the pre-seed or seed stages. Second are liquidation preferences. Take note, super important, as this impacts what you as the founder get paid out if your company gets sold or liquidated. Typically, a one-time liquidation preference is the standard. It can either be senior or pari passu. Senior means that your Series B preferred shareholders would get paid before your Series A preferred shareholders, which in turn would get paid before your seed round preferred shareholders. Pari passu means that your preferred shareholders would get paid on a pro rata basis based on what they invested. It means that if your company goes through a liquidity event like a sale, the preferred shareholders would get their money back before the common shareholders. Imagine your investors collectively put $100 million into your startup and that the company is liquidated for $50 million. The $50 million would be divided among the preferred shareholders according to their ownership of preferred shares. Now here's the sob story for you. Because the liquidation value is less than what your preferred shareholders put in, the $100 million, common shareholders, including yourself, would be left with nothing. In conclusion, understanding these documents and having the right legal support is absolutely a game changer for your startup. Don't underestimate the importance of having a legal expert in your corner. This brings us to the end of the lesson. Thank you for watching, and we'll see you in the next video.